Good morning and welcome to Cornell Cooperative Extension's monthly Consumer Issues Talk. My name is Kenneth McLaurin, a financial management educator with CCE, and today's topic is landlord-tenant relations. We have New York State Assistant Attorney Mike Dana here, and he will discuss this topic with us. Thank you, and over to you, Mike.
Thank you, Kenneth. Welcome, everyone. I'm glad to see such a outstanding turnout here at our Consumer Issues program. As indicated by the number of people that are here to join us, the topic that we're going to speak about today, landlord and tenants' rights and responsibilities, is a topic that is one that draws our largest crowds here to Cornell Cooperative Extension. It also is one of the topics that leads to a lot of calls that our office receives regarding consumer issues. So what we're hoping to do today is really to just discuss the general parameters of the landlord-tenant relationship, rights and responsibilities of both parties, so everybody kind of has a good understanding of what goes on, and if you have questions along the way, feel free to ask them. Kind of the first thing that I like to talk about when we're doing landlord and tenant issues is, what is this whole relationship? What is this whole thing that how everyone gets together on landlord and tenant situations? Well, really, a landlord-tenant relationship is a contract. It's a contract between two parties, one agreeing to give up the use and occupancy of property, and another one agreeing to take over use and occupancy of the property. And other than that, it really isn't otherwise well defined. But the laws are all over the place, meaning you can find them in all different spots as they relate to landlord and tenant situations. It'd be nice to have just a book on the wall that we could pull off and say, oh, this is all the rules related to landlord and tenants. Well, it's not so easy. In New York, we have many different statutes that govern different areas related to landlord and tenant relationships, such as we have the real property law. That would seem to make sense that you would have something there. But we have the general obligations law. We have a thing called the RPAPL, which is the real properties actions and proceedings law. Those deal with eviction proceedings mostly. We may have involvement of the multiple dwelling law. And that's just statewide. We could have local laws as well. And New York City has all types of local laws related to occupancy. And actually, Ithaca does a little bit as well. Most other municipalities, especially in upstate New York, don't have anything related to it. But we always have the overarching state laws that govern it. So we'll start out with kind of what is this contract thing that we talked about? Really, it's just an agreement between the two sides. And one of the first questions that people ask is, well, does it have to be in writing? And in actuality, for a residential lease, you don't have to have it in writing to have it enforceable, as long as it's for less than a year. Now, forget I just said that, because whether you're a landlord or whether you're a tenant, you'd be absolutely crazy to not have it in writing. And I recommend that you have it in writing. So many questions and problems can be resolved if the parties put all of the agreement in writing. It'd be so nice to have an issue come up and you can just pull out the document and say, okay, whose responsibility is this? Oh, it's mine, or It's theirs because it's down in the written document. So it does not have to be in writing, but it should be in writing. And some people would say, well, I'm only going to be on a month-to-month tenancy anyway. So I may only be there a month. I may only be there 2 months. Why do I need to get it in writing? And my response is, it doesn't matter if you're going to be there only a month or a year. Get everything in writing. You can just put the term is only for a month, or the term is month to month, and we'll talk about that in a second, or the term is a year. But it still defines what everybody's rights and responsibilities are. So it's important to get it in writing. So what are the different obligations and responsibilities of the parties on either side? Well, the landlord has obligations out there. What are the landlord's obligations? Well, the landlord's obligations is first to give up exclusive use and occupancy of that property. That means, unless otherwise agreed upon between the parties, the landlord has absolutely no right to go into the apartment. Now, there may be an agreement where the parties agree that they can do that. That's fine. As long as the right to enter is at reasonable times and on reasonable notice. There is another general provision in the law that says in a landlord-tenant situation, any unconscionable contractual provision is void. Meaning, if it is so unfair that it's unconscionable, it would be deemed to be void. Just is not enforceable. What that means is, most of us are reasonable people. We like to think of ourselves as being reasonable people. I know there are people that we all know who may not be as reasonable as we are, but as a general rule, we're all reasonable people. And a lot of the things that we talk about here today, in most instances, we could come up to an agreement. Gets into that little gray area where there could be arguments on both sides. But let's take the example. If the landlord puts in the lease, I can enter your apartment at any time I choose without notice and including 3 o'clock in the morning. I think we would all, as reasonable people, agree that that is an unconscionable contractual provision. The court would not allow a landlord to show up at 3 o'clock in the morning and just say, I'm walking in and looking. So the general rule is the landlord, for a price, the amount of the rent, is giving up exclusive use and occupancy of that premises and may not be there. There could be reservations that are reasonable in the lease. For example, I have to show the apartment toward the expiration of the lease, and therefore have the opportunity to, upon reasonable notice, have the opportunity to show the apartment to other people. And then we'll get into the issue, what's reasonable notice and that sort of thing. And again, we can argue about whether 48 hours or 24 hours is reasonable or not, but the fact still remains is the landlord would have the right in that circumstance to show. The landlord, even absent an agreement or anything, the landlord does have the right to enter the apartment for emergency purposes, to protect their interest or something like that. I use the example, it's a good example to use here in Ithaca. Let's assume that students are residing in an apartment and a two-family, an upstairs and a downstairs. Downstairs is not students, upstairs is students. And on winter break, the downstairs tenant hears water running and looks up and sees there's a water stain forming on the ceiling. The landlord would have the right to go into the upstairs apartment to protect his or her interest in the property. So the landlord's obligation, other than giving up exclusive use and occupancy of the premises, is also that he or she will provide a habitable residence. Every lease has an implied covenant or an implied warranty attached to it. And that is that the apartment is habitable, meaning livable. Livable, safe, and sanitary. Those are kind of the principles to it. And again, as reasonable people, we can mostly agree on what requires, what's habitable. Habitable is that it's safe, secure, and livable, that there is water. We would think you need that to live. Hot water, because we do need hot water. And that there is a roof over our heads. It does not mean that the landlord is required to freshly paint the apartment when a tenant moves in, or that the landlord is required to provide air conditioning. Again, this is the habitability issue. A general rule of thumb, I think, is good to kind of gauge that is code. What are code issues out there, and what would be code for livability? And that's kind of, you can get into every little particular circumstance, but that's a good general rule. The problem occurs, I know a lot of you would be thinking about this out there. A lot of the problem occurs is what happens when, let's assume, there is a breach of the warranty of habitability. What happens? And the answers are not all great for some people, from some people's view. But the idea that the landlord is required to provide a habitable residence. If it is not habitable, the tenant has some options. And one option is the tenant can move. The tenant has a lease for a year. That means both parties are bound together for a year. And let's assume that 3 months into the lease, there's a breach of the warranty of habitability. The tenant has an obligation for 2/3 of the lease to still be bound by it. Well, a breach of a contract, this is general contract law, a breach of a contract absolves the other party of having to fulfill their obligations under the terms of that contract. So if there is a breach of the warranty of habitability, the tenant may move without any further obligation on his or her part. Additionally, there might be damages associated with the breach of contract. For example, the tenant has an expense to move. And in essence, the tenant is being forced out because there is a breach of the warranty of habitability. Then the tenant could sue the landlord for the expenses that they incurred as a result of the breach, which would be moving expenses to have to move to another place. Now, I don't know if there's ever been any cases that ever been decided is what happens if you move to another apartment and have to pay more rent for that period of time. It's conceivable. I can think of circumstances where the tenant might be entitled to receive the difference in what they should have been paying and what they ultimately paid. And there's a lot of factual questions that get involved, like what if the tenant moves into the Taj Mahal from a nice 2-bedroom apartment? Does the landlord can the tenant get the difference? Probably not. It would have to be like, kind, and quality of place. And it would also have to be reasonable as well. The landlord, if it's again, assuming that it's a breach of the warranty of habitability, the tenant could fix what needs to bring it up to habitable condition and charge the landlord back. Now, there is a possibility that the tenant could say, I am not going to pay rent. I'm going to withhold paying the rent until this thing gets fixed. Yeah, that might work. I don't usually recommend it. I don't think that we should hold our rent hostage to create force the landlord to do something. I think the better procedure is to find out how much it's going to cost to fix and use that as the gauge for making it habitable and to bringing the apartment back, and using the money that it would cost to do that from the rent if the landlord doesn't pay to have it done. I think that's a better course of action. And I'll use an example. Let's assume for the moment that the rent is $700 a month and the furnace breaks. And we'll use other factual scenarios, such as that the landlord has been contacted and just hasn't fixed it within a reasonable period of time. What do we go about doing? Well, let's say the cost of fixing it is $500. So rent's $700, the cost of fixing it $500. Rather than saying, I'm not paying my $700 a month, a rent this month, until you fix that. I'm not going to pay you next month. So I'm not going to pay you the months after that until this thing gets fixed. I think the tenant would be much better off saying it's a $500 fix. I had somebody do an estimate. It's $500 fix. Landlord, here's my $200 to pay the remainder of the rent, and here's the receipt for $500 that I paid to fix the furnace. Because what that does is you run the risk that if you just withhold the rent, you're buying yourself an eviction proceeding first. You go into court, then what if the judge says, well, you didn't need to have, you shouldn't have withheld $700, and therefore I am finding that you didn't pay the rent that was due, and I'm signing the warrant for the eviction. That puts you in a strange position. Much better to go in and say, Judge, this petition should be dismissed. And the judge says, why? He says, because I did pay the rent. What do you mean you paid the rent? The landlord's saying you didn't. Well, no, I paid the $200, and here's proof, and the landlord admits that I paid $200. And here's the receipt for the $500 to fix the furnace. I had to fix the furnace because the landlord didn't do it. So I've paid $700. The judge is going to say, well, the rent has been paid. So I think it's much better, rather than running the risk that, maybe you got a good shot at the judge saying, hey, the furnace needs to be fixed and the rent's not due. But I think this is an alternative that might work out better. So you could sue. You could also sue for a reduction in the rent. Say, I haven't had rent, or I haven't had heat, and or the apartment isn't habitable, and it's not going to be habitable until X number of dollars gets paid. I want a reduction in my rent. Or I haven't been able to use part of it's a two-bedroom apartment, or two-bathroom apartment. I haven't been able to use one of the bathrooms because it's broken and the landlord hasn't fixed it. I want a rent reduction. And the judge could award a rent reduction. In the case of an emergency, the tenant, you always have to put the landlord on notice. The part should be communication. Usually the problems come to our office when the communication is broken down completely. There should be an attempt to contact. I recommend this for landlords too, write down when the communication has taken place or attempted communication has taken place. Tenant calls and leaves a voicemail message. Write down when you called and left the voicemail message. Landlords, if you get a voicemail message from your tenant, write down that you received a voicemail message and what time it was that maybe the message was left on your phone, and the time that you were able to get to it. And if there were multiple instances of it, write it down so that you have a record of it, because that's the proof that the tenant has that they made reasonable attempts to contact the landlord. The landlord could come in and say, tenant, so you know this, the landlord could come in and say, she never called me. I never got a message. I never knew that there was no water in the apartment. The tenant could have a record of saying, I called at this time, on this day, and this time, and this time, and this time. So I left a message on the voicemail, or the voicemail box was full and I couldn't leave a message. So the landlord's saying, I never got a message. Well, that's because you didn't clear your voicemail. And so the tenant can keep a record of that. Just makes a lot of these things come down to proof problems, and that helps in the proof area to say when the contacts were made. Let's assume for the month, this is the bad part, okay? This is the bad part for the tenants. let's assume for the moment that the landlord says, yeah, it's so breach of the warranty of habitability, it's a dump, I'm not fixing it. And the tenant says, what do you mean you're not fixing it? And he says, I'm not fixing it. There really is no provision to make the landlord fix it. The only thing that the landlord can be made to do is not rent the apartment to anyone. So the landlord can be directed to fix something and be fined by local code for not having it fixed. But the only reason why they're fined is because they have an apartment that someone is renting that they haven't fixed it. If the landlord says, I'm not fixing it, and doesn't rent it to anybody, there's nothing that can be done. So the problem with code is if code steps in and they say, hey, this is a safety issue and you have to get out, the tenant has to get out. And it's in their safety interest that they get out. I understand the problems associated with it. I really do. I understand it. But there really is no provision to say, landlord, you have to fix this. The only thing that can be, landlord, if you're going to have somebody live here, you have to fix this. And it may cause the tenants to have to move. And that's the unfortunate part, but that's just the way that it is. There isn't a way to say, you have to fix this, except to say you have to fix this if you want people to reside in this place. I would encourage people, if there is a what you believe to be a warranty issue, a warranty of habitability issue, or a code issue, or something like that, contact code enforcement. There's an active code enforcement office here in the city of Ithaca. The code enforcement offices operate municipality-wide. So if it's a town of Lansing or something else, you'd have to go to the particular town or municipality in order to wage the complaint. Next thing and that comes up frequently is what obligation does the landlord have for noisy co-tenants? The way you have to look at it is tenants, your apartment, even if it's 4 units, one of 4 units, is like your own house. And you have to treat it as if it's your own house. And how would you treat if you had noisy neighbors having a party at 3 o'clock in the morning next door? Well, you'd have to call law enforcement, and that's the same here. It's not the landlord's obligation to make other people quiet down in the apartment. However, understanding that, a good landlord, and most are good, does not want one tenant ruining it for 3 other tenants, because he knows he's going to have a vacant apartment building if he doesn't take care of that issue. So you should, yes, in fact, notify the landlord of the issue, because the landlord does hold that over the tenant's head and maybe won't renew the lease of the noisy tenant, get somebody else in there, or try and get the person out of there in some way. So still inform the landlord. I've heard some people argue that, or try to argue that it might be a breach of the warranty of habitability if there's a noisy co-tenant. That I never heard one way or the other if that would ultimately work, but still at least notify the landlord about it. The landlord has the obligation, if there's a breach of the warranty of habitability, to fix it within a reasonable period of time. There's that term reasonable. I often say when I'm out here at Cornell Cooperative Extension, the term reasonable is a term that lawyers are paid a lot of money to define. Because reasonable is reasonable, and I guess it's in the eye of the beholder, whatever reasonable. But again, we can probably agree in most instances as to what reasonable is. And so if the landlord doesn't fix it, and I like the term reasonable, And you sit there and say, well, it would be so much easier if it was black and white. 24 hours, 12 hours, 48 hours, then we at least know. Because on the 24-hour and 1 second time frame, then I can get on it if he has to do it within a reasonable period of time. But I like reasonable. And I'll tell you why. Let's assume, for the moment, that we have a breach of the warranty of habitability. And the warranty of habitability is there's no heat. Okay? And so you call the landlord up, and the landlord receives the call and says, okay, I'll get that fixed. Now, what's the reasonable period of time to fix the heat? What do you think? 24 hours? What if it's July 4th? Well, you don't need heat on July 4th. What if it's January 1st? 24 hours may be too long. So I think that's why it's reasonable given the circumstances. So if it's the middle of winter, landlord, you better get on it right away. If it's May, not so much. A little cool in the mornings, but maybe you can take a little bit of time. So that's why reasonable is good. It depends on the circumstances. So landlords are required to get on it, and excuses of my maintenance guy's on vacation, he can't get to it in a week. That's not reasonable at January 1st. So I think the best rule of thumb is landlords, put yourself in the shoes of the fact that what if it was your house? That's what you have to view it as. Tenants have to view it the same way because it is your house, and you have to treat it as if it's your house. And so acting reasonable under those guidelines works pretty well. And so repairs must be made in a reasonable fashion and at reasonable times. Another issue that frequently crops up with landlords and tenants, and in this case we're dealing with landlords' obligations, is how does the landlord handle security deposits? Now, some people think that there's something written in the law that makes the security deposit 1 month's rent, because everybody thinks, it's typically, you got to pay first month. Well, sometimes you got to pay first month's, sometimes last month rent, and a security deposit, which is 1 month. So sometimes you have to have 3 months, at least 2 months, first month's rent and security deposit. There's nothing that says that it has to be 1 month. It could be more than 1 month. Of course, if the security deposit is too high, that kind of defeats the purpose. And, if tenants had to come up with so much money all at once, lots of times they would go buy a house. And then they'd have it themselves if they had all this money. So it's just worked out that we just take for granted that it's 1 month's rent. How does the landlord have to handle the security deposits? And you can answer that question very simply if you know the answer to one question, and that is, whose money is the security deposit? It's the tenant's money. Okay. That's true, by the way. It is the tenant's money. If the landlord receives a security deposit, can she put it in her checking account? No. Why? Because it's the tenant's money. It's the tenant's money. It's not hers to put in her account. So the rule is you cannot commingle security deposit with your own funds. You must keep it separate. So it's very simple, landlords. I've had landlords say to me, oh my gosh, and it's no big deal. You just open another bank account. And the only thing you put in that bank account is security deposits. You don't have to have a bank account for every tenant, and then you have 20 bank accounts. No. You just need one bank account that only tenant money goes into. And you have to keep records of whose money goes into that account. And when you give it back, then you give it back. If you overdraw your security deposit bank account, you are in trouble because you are using somebody else's money to pay something. And you can be in big, big trouble for doing that. So you keep records. You have to keep it separate. Let's assume for the moment that you, landlord, that you have all the security deposits and you keep it in a separate account. Good. And it's in an account that has interest. Who gets the interest? Tenant. Why? It's the tenant's money. Oh, you're so good. You're so good. It's the tenant's money. So the interest belongs to the tenant. Now, there are some rules that go along with it. If the unit is 6 units or more, it must be in a New York bank. Must be. If it's 5 units or less, it doesn't have to be, but we still fall back to our original principle. It can't be commingled. The interest belongs to the tenant. However, there's a little asterisk next to that. Does anybody know what the asterisk is? The asterisk is that the landlord does get to keep 1% as an administrative fee for administering the account. So in this day and age, as we currently stand, 2016, our discussion is theoretical. Because if any of you have seen the interest rates that are being paid on savings accounts, you will see that they are less than 1%. And so really the landlord could keep that particular interest. I know many who don't. They just don't want the hassle. They just give it back. But when I first started coming out to Cornell Cooperative Extension, which was over 18 years ago, it just drives me crazy to think that I've been doing it this long. Interest rates back then were like 3% on savings accounts. So it wasn't a theoretical argument. And who knows? Maybe when we do this next year, it won't be as much of a theoretical argument. The interest rates will have increased to where we're getting the return on the money. Who knows? But the rules are still the same. And so the landlord has to treat it as if it's somebody else's money. Again, it remains the property of the tenant and has to be treated accordingly. What happens to the security deposit if the property is sold? Landlords need to be really aware of this. Hopefully you have an attorney that's representing you on the sale of the property. Is the security deposits should be transferred over to the buyer. If they do not, you are still on the hook. So I think if a landlord is trying to ends up selling the property, they don't want to have anything to do with it anymore. Make sure the security deposit goes over to the buyer. Buyers, future landlords, buyers of property, be very careful to make sure that when you buy the property, all the security deposits are transferred over. And in some instances, the transaction can take place to where all the funds are washed with each other. There's some additions, there's some deductions, and then a bottom line check goes over. Well, if that's the case, in all likelihood, the money that you pay over to the landlord is probably after deducting what was in the security deposits, which means you've gotten the security deposit. You don't get an actual physical check, but it's in the numbers. You have to make sure that you go take money and put it in a separate account because you did get the money and you are now on the hook. And technically, you have commingled the money because you haven't separated out of your own money. So make sure you just, even if it's an extra check you have to write, I know you paid the seller already, but you got to dig in your pocketbook and pay some more money. Set up that account and put the money in it so that it gets taken care of. So the seller should transfer to the buyer, and if not, the tenant could sue the prior landlord to get their money back. So know that ahead of time. When must the security deposit be returned? Anybody know when it must be returned?
Within 30 days of the move out.
within a reasonable amount of time. There's that term again, unless you live in the city of Ithaca. City of Ithaca actually does have a local ordinance that says 30 days. But let's think about that for a second. Are we really much different from each other? Reasonableness, 30 days. It's probably pretty reasonable. If the tenant moves out, I know it's spick and span. They want their security deposit back right away. It's their money. Why not? Why shouldn't they get it back? Well, the landlord should be given a reasonable amount of time to look, inspect, if something needs to be repaired, get estimates, and that sort of thing. So I think we all, as reasonable people, can agree that 30 days is probably a pretty reasonable period of time. Now, the city of Ithaca has actually adopted an ordinance that says, in essence, that 30 days is what the time period is. Maybe it's 2 weeks, maybe it's 6 weeks, depends on the circumstances. If you're getting outside of 30 days into the 6-week period of time, you're starting to get into the unreasonable range. And if you're demanding it after 10 days, you're getting into the unreasonable range. So I think a good framework is, a good estimate is a 30-day period of time. So that's the landlord's obligations. We move over, and I know that there are tenants' rights. We talked a little bit about what those rights are when we're talking about the landlord's obligations. But tenants also have obligations. The first and foremost, the obligation of the tenant is pay the rent. Pay the rent and pay it on time. The landlord is not as nice as your landlord is. The landlord should not be expected to have to wait because a tenant has some bills they have to pay that month. The landlord has bills too. So the obligation is to pay the rent and pay it on time. Another obligation that the tenant has, and it falls back to one of the principles that we talked about earlier, which is the tenant has to treat the property as if it's his or her own, as if they owned it. The tenant has the obligation to keep the property up. The tenant has the obligation to treat it as if it was their own, because it is. They're having exclusive use and occupancy for the term of the lease. And it must be returned to the landlord in the same condition that it is received, and I'm going to use that term again, reasonable wear and tear accepted. Meaning, in the normal course of living in a place, we expect there to be some type of use and wear to the property. That usual, customary, reasonable use of the premises is what is expected. And the property is to be returned knowing that there's going to be some reasonable use and wear and tear. So that is part of what the rent is being paid for. And the landlord has to expect that there's going to be some deterioration over a period of time, and that is what they're getting the rent for, and should put some of the money aside so that it has to be painted, or the carpet might have to be replaced, or something else has to be fixed, or something like that. And again, we had that term, reasonable wear and tear accepted. What does that? I think in most instances, we as reasonable people can agree to what is reasonable wear and tear. If somebody resides in the same apartment for 10 years, and they have a doorway that is the common doorway, that there may be a couple of doorways, but everybody really uses this doorway. And the carpet gets a wear mark in the carpet over the 10 years wearing it down. When they move out, the landlord can't charge the tenant for the wearing out of the carpet through normal use. Likewise, the tenant can't be charged for the repainting of the apartment as long as it is reasonable use. If, however, the tenant has an aspiring young 2-year-old artist who decides to use crayons to draw a mural on the wall, that is not reasonable wear and tear. And you can't say to the landlord, you knew I had a 2-year-old when I moved in, and 2-year-olds will be 2-year-olds. No, that's not reasonable wear and tear. Holes in walls are not reasonable wear and tear. Reasonable wear and tear are just customary use of the premises. And so the property must be returned, reasonable wear and tear accepted, and that it should, how do we resolve that issue, or how do we make sure that everybody's protected there? This is a classic example of the phrase, pictures speak 1,000 words. Pictures in and pictures out, or video, in this day and age, video in and video out. Landlords, video in and video out. This way you can document what is wrong with the apartment. I know we have walkthroughs, and I think that's a really good idea, both before and after, and to have that condition sheet that a lot of times you have to sign. But there may be things that some people miss or something like that. Take a video as well and just keep it so that you have a picture before and after. Just solves so many problems, because if you go into court afterwards and you didn't get your security deposit back, so the tenant has to sue to get their security deposit back, and the landlord comes in and says, it was a mess. It was a mess compared to what they took over. And of course, the tenant always comes in and says, it was a disaster when I moved in. I put in all my sweat equity and cleaned the whole place up and made it sparkling. And when I moved out, it was so much better than when I moved in. And the judge is going, eeny, meeny, miny, moe. Judge, here's a picture of what the kitchen looked like when I moved in. See, the burner tops are all corroded and rusted and a mess and food and grease all over it. And here's what it looked like when I was out. Granted, there's still some in there, but if you look at it, it's either comparable or even better than when I moved in. I shouldn't have to pay for that. How much better than that is the landlord coming in and said, no, it was great, and the tenant coming in and saying, no, it was a pigsty. So pictures speak 1,000 words. Take pictures or video going in, and then when you go out. And it's a lot better when it comes down to it at the end. Security deposits, landlords. We kind of fall back to the condition of the apartment and handling of security deposits. The whole reason behind the rule that you can't commingle security deposits with your own funds is because when you commingle something, it kind of takes out a new ownership, takes on a new life and becomes part of yours, and that the landlord could believe that, at the end of this lease, I actually have to dig in my own pocket to give the money back. Security deposits are not additional rent. They are only there for the one purpose, and that is to secure the condition of the apartment upon return. Not as additional rent or anything like that. So that's why it can't be commingled. Keep it separate. Then it doesn't seem like you're giving back somebody, you're having to dip in your own pocket to give the money back. Again, there's a very active code enforcement office here in Ithaca that at least the city of Ithaca, I don't know about the outlying towns, I'm sure that it's all good as well. We have so many issues throughout New York State with our office with security deposit questions. We actually have our own security deposit complaint form. We have a complaint form just for rent security deposits. So if someone were to have a problem, they didn't get their security deposit back or something, would like to file a complaint with our office, you can actually find a rent security deposit complaint form, or we can send you one, and you fill it out and send it in, and we will try to mediate that to resolve the issue. So what happens at the end? And the lease is coming to a conclusion, and the tenant has not fulfilled his or her obligation, number one, which is paying the rent. What ends up happening? Well, the tenant can be removed from the property. Another rule, landlords, you may not undertake your own personal eviction proceeding by changing locks, shutting off utilities, water, electric. You may not do it because, remember, you have this relationship that was created where you gave up exclusive use and occupancy. And until that terminates, you have no right to do any of that stuff. So how do you terminate that exclusive use and occupancy? You have to go to court. The court can sever it. That's called an eviction proceeding or a summary proceeding for the recovery of real property in legal terms. It's a relatively quicker proceeding. It's an eviction proceeding. And what do they have to do? There's two different kinds. They're similar in some respects. One we don't have to worry about as much, which is the holdover proceeding. That means when the lease expires and the tenant won't leave, the landlord can bring a proceeding to evict them as a holdover tenant. The more common proceeding is the proceeding for failure to pay rent. And that's the one that's much more common. First of all, let's talk about the term of the lease itself is what the parties agree to. Remember, if it's a year or less, then it doesn't have to be in writing, but you get into a whole bunch of problems with that. And the typical lease that we normally talk about is a year lease. That's how it always seems to be. That's a lease for a specific term. It doesn't have to be a year. You could have a 6-month lease. You could have a 3-month lease. If it is not otherwise agreed upon, so the tenant comes and looks at the apartment and says, oh, this is a beautiful place, and the rent is very reasonable. I agree to pay $500 a month for the rent. The landlord says, you know what? I like you. I want to rent it to you for $500 a month. Okay, we have an agreement. How long is the lease for? You have an agreement. The law presumes it's month to month. So absent an otherwise agreement, it's month to month. Likewise, after the 1-year lease expires, it converts to a month to month unless the parties otherwise agree. It doesn't convert to another year lease or anything like that. It converts to a month to month. What's a month to month mean? Month to month means you have a new lease every month. It renews every month. Just think of it as a brand new lease. Nobody says anything to each other, but it's really a new lease every month. So, that being the case, how do we end it? And the rules are the same for both parties. I've had some people come to me who are tenants and said, oh, the rules all favor landlords. And I've had landlords come to me and say, you know, the rules all favor tenants. And that tells me that it's probably right down the middle. And in this case, it's right down the middle. And that is either party can get out of the lease on 30 days notice before the beginning of a term. So if you go typically first of the month to the end of the month, then the notice by either party has to be given to the other side before the beginning of the next term. And then the lease terminates at the end of that term and the tenant must be out. Likewise, if the tenant wants to get out, they give the landlord notice before the beginning of the term that they're going to be out and the landlord can't hold them any longer so that they're able to get out. So it's fair on both sides. Let's assume for the moment that we got a lease going along and everything's going great, except the tenant has some car problems and has to fix their car that month. Otherwise, they can't get to work, and so they don't have the money to pay for the rent. There are very strict rules that have to be met in order to do an eviction proceedings, and that landlords and tenants should be both aware of them. Landlords in particular, because you might have to start all over again if you don't do it right. Here are the rules. Before the landlord can start an eviction proceeding for the failure to pay rent, they must give what I referred to as the first 72-hour notice. They must give a 3-day notice to the tenant. It must be given to the tenant in the same manner that a court proceeding would be given, which is it should be served on the tenant. And it's a real simple notice. You can get it, legal stationery stores or something. You can get it. It pretty much says you have rent that's due that's $500 a month. Rent was due for May 1st. You have not paid it. You owe $500. Pay it within the 3 days, 72 hours, or vacate. So the tenant has two options. Pay, and then the eviction proceeding is gone. Or don't pay and see what happens. It wouldn't be good for our story if they paid, because then it would all be over with. So what happens at the end of the 3 days? Now, again, that's a precondition to starting the eviction proceeding. You must have given that notice. The next step that the landlord has to take is they have to take the tenant to court. And the tenant is entitled to receive, we have a Constitution in the United States, and one of the fundamental principles of our Constitution that we have proceedings that require notice and an opportunity to be heard. That's the whole fundamental system that we have here. We don't just all of a sudden convict somebody without giving them notice of what they're being charged with. Well, in this case, you have noticed that you have to be in court because there's going to be a hearing on the rent that's owed. And it's going to be on such and such a day where you have the opportunity to be heard for your side of the story. So you have to be served with a notice of petition, which is the notice of when you have to be in court, and a petition, which is the allegations against you. And it's the landlord's allegations. And the allegations are, landlord's the owner of property, leased it to the tenant for X number of dollars a month, rent was due for May 1st, rent has not been paid, a 72-hour notice was previously given to the tenant, and the tenant has neither vacated the apartment nor paid the rent. I want my exclusive use and occupancy back. In other words, I want that relationship severed by the court. And then here's the important thing. That notice of petition and petition must be served on the tenant between 5 and 12 days before you're in court. So the simple thing is, you find out what date that you have to be in court. You count back 5 days and mark it. You count back 12 days and mark it. And in that 7-day window is the time that the tenant has to be served. If you serve that petition 14 days before you're in court, must be dismissed. If you serve that petition 4 days before you're in court, it must be dismissed and you have to start over again. So you have to get that 7-day window and serve it on a tenant. I guess it's a theory of you have to give them notice, but not too soon and too late. And assuming that's the case, the parties show up at court. The court says, I have a petition. It says that you owe the rent for $500. Mr. Tenant, what do you say? And Mr. Tenant says, it was a little tough this month. I'll have the rent in a week. I guarantee it'll be paid in a week. Well, really, the judge can say, I'm sorry, we're in court today. It's due today. Now, if you pay the rent any time prior to court, it's over because the rent has been paid. But if it's not, there is no excuse. It has to be paid. There's no exceptions. It has to be paid. Now, the respondent in this proceeding, the tenant, could come in and say, I did pay the rent. Here's the $200 check that I gave for the rent and the $500 for having the furnace fixed. Then it's paid. But it might be, I'm sorry, I won't have it. Now, there are some judges that may say, okay, here's what I'm going to do. I'm going to hold off signing the warrant for 3 days, or I'm going to make it effective sometime later. And if it's paid within that period of time, I'll rescind it. There's that possibility, but don't bank on it. It's not a given. It might just be to the courtesy of the judge doing that. So it must be paid on that time. Let's assume for the moment that the tenant has no excuse, didn't pay. The judge then signs a thing called a warrant. Doesn't mean anyone's going to get arrested or anything like that. It's just a direction that the property is to be returned to the landlord. What the landlord then has to do is take that to the local enforcement officer, and it depends. It's usually the civil division of the county sheriff. Some municipalities have town constables. We used to have a lot more of those 30 years ago when I first started practicing. Most of them don't have them anymore. Or a city marshal. They're also can do it. I don't know if there's any city marshals in the city of Ithaca. But usually it's the civil division of the sheriff's office. And you give that to the sheriff. And depending on the sheriff whose office it is, they may have their own form for a notice of warrant. Or you have to prepare the notice of warrant for the sheriff, and it's simply a piece of paper that says, the sheriff signs it, and it says that we are going to return with, here's the warrant, a copy of the warrant. This is your notice that we are going to return within after 72 hours. If you are not out of here, you will be removed. And that gets served by the enforcement officer on the tenant, and the tenant has 72 hours to get out. In all my years of experience, I've never had the situation that I can recall that anyone has actually had to be moved out. I have had situations where I remember one occasion when I was back doing these things 25 years ago, where the enforcement officer went back after 72 hours and knocked on the door, and the tenant answered the door and said, I know, I'm going, and just finished getting their stuff out and got out. But it could be that the tenant has to be moved out. Now, how does that all happen? Well, the sheriff doesn't come with a posse and start moving furniture. All the sheriff's responsibility is to keep the peace. Well, the landlord makes arrangements to move. And what does the landlord have to do? The landlord has to act reasonably in that circumstance. And reasonably means not throwing things out of the second-story window. It's maybe the locks can be changed. Maybe there's a garage or storage area out back that the stuff can get transferred into if the property has to be locked up. The landlord is not required to store the property for the tenant if the landlord doesn't have the ability to do that. If worse came to worse, it might have to go out on the curb. It may have to be. It's reasonable again. If there can be, I've heard of landlords where they had a storage area and they put things in storage and locked it up so that it could be taken care of. The thing that the landlord has to understand is that's the tenant's property. It's not yours. Even though it bugs the heck out of you that you're owed $1,000 in rent, you can't keep the tenant's property as hostage until they pay the rent. They are entitled to get their stuff. Let them have their stuff. You may have a judgment against them for $1,000, but they get their stuff, and you have to allow them to get their things. Now, the landlord, in addition to, if the papers are personally served on the tenant, not only can the landlord get the property back, but they can also get a judgment for the amount of rent that's due and owing. Let's take the circumstance that in that 3-day window, the first 72-hour notice, the tenant moves out. The landlord says, what the heck am I going to do now? They moved out. Well, that terminates any potential eviction proceeding, but it doesn't terminate the landlord's right to collect from the tenant the $1,000 that's owed. It's just rather than going in for a summary proceeding for the recovery of real property, you would go into small claims court to get a judgment against the tenant to try and get your money back, and that's how the matter would be handled. So those are the rules kind of related generally to landlord-tenant rights and responsibilities, and our time is coming to an end. But if you have any particular questions related to the tenant-landlord relationship, I would be glad to answer them. Anybody have any questions? Have a question? If you have a question, go ahead.
You didn't speak about it, but I wanted to know, but I guess that must be another workshop because I didn't hear anything about the discrimination law, and I wanted to find out something about the new HUD guidelines for formerly incarcerated.
Okay.
But that might be another workshop.
Well, let's talk about, first of all, that's a great question. I'm not aware of HUD's rules. That HUD kind of has its own rules, and I'm not aware of those. But you did raise some important things. One is discrimination. Housing discrimination is absolutely prohibited. Absolutely. What is discrimination? Discrimination is race, creed, color, national origin, sexual orientation. You cannot discriminate against those who fall within a suspect classification because of their suspect classification. Now, again, it's limited to those certain categories. Low income is not a suspect classification, so it is not a discrimination category. Also, rules related to HUD, they have certain funding rules. It's kind of the golden rule. The person that has the gold makes the rules. So whatever HUD's requirements are HUD's requirements. That's just a funding requirement, and I don't deal with those particular things. However, there is another issue that's really important, and that is this drives landlords crazy. Drives them absolutely crazy, and I can understand why. Landlords cannot prohibit tenants from bringing in others to live with them to a certain extent. The outside parameter is code. So if there's occupancy rules, like it's a 2-bedroom and you bring in 15 friends to live with you, that's a local, safety issue. But the law says that a tenant is entitled to bring in their immediate family, so it'd be a spouse and their children, and one unrelated person and their immediate family. So the thing that bugs landlords sometimes is they put in their lease that says, this is a 1-bedroom apartment. It is limited to John Smith and John Smith only. That provision is void. It is against the law. If John Smith brings his girlfriend in, there is nothing you can do about it. If John Smith brings his girlfriend in and her 2 kids, there is nothing you can do about it. You can't increase the rent. You can't evict them. They have the right under the law to bring them in, and you can't do about it. So what does that mean? It means, landlord, you have to anticipate that that's going to happen and include it as part of the rent. So tenants, you may say, gosh, I have to pay an extra $200 than I might otherwise think I would have to pay. That is, that's just the cost of the rent. There's no rent prohibitions. Oh, another issue as far as rent prohibitions, there is no prohibition as to the amount of the rent increase. If you're paying $500 a month and the landlord comes and says, okay, the rent's going up to $1,000. Oh my gosh, there is not, as long as it's not being increased as a result of discrimination, it's the landlord place. The landlord can decide who he or she wants to rent to and how much he or she wants to rent for. And that's just the way that it is. We have a question in the back.
Yeah, I just wanted to ask you on that eviction piece. So when is it when you don't pay the rent's due on the 1st, when is it when the landlord says, okay, I'm going to start eviction?
Very good question.
Do you have in between from not paying it when it was due within that month?
Very good question. And I'll repeat the question because we have the millions of people out in television land who watch this show every month. The question was, how much your rent's due the 1st of the month. So how much time does the landlord have, or does the tenant have, till the landlord can start that 3-day notice? Immediately. The rent's due on the 1st, not paid on the 1st, then the notice can immediately go out. And sharp landlords are all over that and will get the thing started right away. Because when you think about it, with our time periods that we're talking about, it may take 2 weeks, 3 weeks, 4 weeks to get somebody out. when you have to, all these time periods. So at the earliest, you've got 3 days for the first 72-hour notice. Then you've got 5 days for the petition. So we're up to 8 days. Then you've got 3 more days for when the second 72-hour notice goes. And of course, you're going to have some lag period within there. You're talking a couple of weeks already to get it going. So you'd really be sharp to get started on it, because if the landlord hasn't paid after 5 days, you're now almost to the end of the month before you're ever going to be able to get it taken care of. So that's how. Another question.
Going back to security deposits, is it legal for the landlord to say, well, $100 of the security deposit is non-refundable for cleaning?
Can the landlord say that the $100 of the security deposit is non-refundable because it's a cleaning expense? That is the gray area that have not been tested yet. First of all, for landlords, I would tell you that that's a slippery slope. You may be thinking, hey, I'm doing good here because if I get the place spick and span, I'm going to make an extra $100 on the deal. Well, you run the risk of the tenant saying, what the hell? I'm not cleaning this place up. I've already paid them $100. And you're going to end up having more hassles than anything else. It's really, that comes down to whether it's reasonable or not and what the parties agreed to at the beginning. If the parties agreed to at the beginning, it's less of an issue because at least the parties know that going in. It is absolutely prohibited if it's not something that the parties agreed upon and at the end, and then you get down to you can only keep as much as you're entitled to, and that's it. Then we had one more question, then we'll have to close it off.
Can they say 60-day notice, or do it have to be a 30-day notice? Or can the landlord say, we give you a 60-day notice? You have to have a 60-day notice before you can move out.
The landlord says in the written agreement that you have to give me 60 days notice before you move out. I would say that if the parties agree to that, then it probably is going to be okay, as long as the parties have agreed to it on notice ahead of time. Because in the initial instance, the tenant does have, maybe it's a theoretical argument, but the tenant does have the right to walk away and doesn't want to. One last question that we want to get on TV.
So the security deposit, if a landlord lets someone move in before all of the security deposit is paid,
Landlord lets somebody move in before all the security deposit's paid.
and then when they don't pay it off within a certain period of time, start charging late fees for that security deposit?
Then if
Or they let them move in before?
the landlord lets them move in, but then starts charging them a late fee for not having paid the balance when they were supposed to pay it. That's a problem for the landlord because the security deposit is the security deposit. Now, I don't know that it's, unless otherwise agreed, it's not considered additional rent, so you're not late on anything. But it may be if it's in the agreement that you can start charging it, and I'm glad, then I think you probably are able to do that. The other issue comes in, and I'm glad you raised it, which is late fees, late payment fee. They must be reasonable, or they would be considered to be unconscionable. And I think it has to have some correlation to what the expenses of the landlord is. It's not a cash cow for the landlord. So late fees of $25 a day that never ends would seem to be pretty unreasonable, and you're going to have a difficult time collecting that sort of thing. But if it was $25 for the month, or it was a smaller charge per day, then you probably are going to get away with it, and rightly so. I mean, the landlord has expenses, and they have to dip in their own pocket otherwise. Thank you very much for coming. Your questions were great. I wish you would all come every single month. Put it in your books. Come in for talk to about all our different consumer issues. I'm going to hand it back to Kenneth to do our exit and to inform you as to all the different times that we're here, and hopefully you'll come out and join us sometime. So thank you very much.
We'd love for you to come down and be a part of this as it's happening live every second Thursday here at CCE Tompkins, 615 Willow Ave, Ithaca, New York, 11 a.m. Have a good evening, and hopefully we'll see you next time. Thank you.